Val.
Thank you, Mr. Speaker. One thing that the previous speaker has just said I will agree with, and that is that we do have a problem with domestic violence in this country, and anybody who looks at the statistics will be able to confirm that. In 2008, the police responded to over 82,000 incidents involving some form of that sort of violence. Between 4 and 10% of New Zealand children report experiencing physical abuse. 24% of girls and 11% of boys report such abuse. And in 2007, 6,400 children were involved in applications for protection orders. Most of them had witnessed violence, and some had been subject to violence directly. Sir, at the same time, there's been an increase in the international movement of children, as my colleague indicated earlier, for adoption purposes. And current powers are inadequate, quite clearly in the legislation, to deal with this phenomenon. It is obvious that New Zealand needs laws that better allow the prosecution of offences relating to inter-country adoptions. And really those are the reasons, sir, why Labour introduced the Domestic Violence Reform Bill in 2008. As has been pointed out, this legislation reenacts many of the provisions that appear in that bill, and so we've decided to support the legislation. There are 3 particular provisions in the bill that I want to highlight because they are the basic and essential reasons why we are being supportive of the legislation. The first is the set of provisions amending the Domestic Violence Act 1995. Clause 6 of the bill would amend Section 16 of that Act to make clear that a protection order will apply for the benefit of a child of an applicant until the age of 17, unless the order is discharged earlier. That is really important. The bill also clarifies that a protection order that has not lapsed or been discharged continues for the benefit of any child of a deceased applicant until that age of 17 as well. The Domestic Violence Act at the moment, sir, is silent on those matters. The bill also would insert in the Domestic Violence Act a provision to put it beyond doubt that the family court can make interim orders relating to a child's care or to vary existing orders even if there hasn't been an application filed. And finally, as far as the Domestic Violence Act is concerned, the bill makes it entirely clear that any lawyer appointed to act for a child under the Care of Children Act may, as of right, be present at a hearing of proceedings under the domestic violence legislation. So the second set of provisions, clauses 17 to 28, amend the Care of Children Act. The bill will provide that where a protection order has been made against a party to an application for a parenting order, the court may make an order allowing that party day-to-day care or contact with a child only if the court is satisfied of the safety of the child. And if there's any doubt or any sort of mid-stream view as far as the court is concerned, then the court can make an order for supervised contact between the child and the party. The bill also strengthens the protection for children for unlawful removal from New Zealand, and it's the final set of amendments, clauses 29 to 35, amending the Adoption Act, that I just want to turn to now. As Leanne Dalzell said, these amendments would ensure that New Zealand can ratify the optional protocol to the United Nations Convention on the Rights of the Child on the sale of children, child prostitution and child pornography. The bill will amend the Adoption Act to create a new offence of improperly inducing consent for the adoption of a child. This offence will be punishable by a maximum term of 7 years imprisonment. As has been pointed out, that makes it, under the law and under the treaties to which we're party, an extraditable offence, and that allows us to ratify that optional protocol to the Convention. Mr. Speaker, I've said that Labour will support the bill, but I think members will have gathered that we don't do so uncritically. The exchange between the Minister and my colleague earlier indicated that Labour's Domestic Violence Reform Bill remains on the order paper. Well, sir, we're a bit mystified on this side of the House as to why that legislation simply isn't progressed, because Labour carried out extensive consultation and research before introducing it, and it would have been preferable if National had done the right thing, not played politics and rebranded the legislation as its own, but simply got on and speedily progressed our bill through Parliament. Instead, like many aspects of National's program so far, the introduced legislation just rehashes much of what was proposed by Labor and rebrands it as National's own. Sir, it does so imperfectly, and there are 5 areas that I want to point to where this bill doesn't go far enough or fails to make important provisions. The first is that Labor's Domestic Violence Reform Bill changed the definition of child in the Domestic Violence Act to someone under the age of 18, and this was in compliance with the United Nations Convention on the Rights of the Child. Currently, a child is anyone under 17, so if Parliament passes the current Act, it will be non-compliant with our international obligations. And as Leanne Dalzell said, this is especially ironic in light of the pains that the current bill takes to allow for ratification of the optional protocol to the Convention on the point about creating an extraditable offence where trafficking or other serious crimes concerning children are committed. Secondly, the bill does not provide the court with the power to direct attendance at an addiction treatment program. Labor's bill did this, and if National was serious about dealing with the causes of crime, this bill would as well. Thirdly, Labor's bill introduced a provision requiring any judge who declines a without notice application for a protection order to provide written reasons for declining the application. This was to make sure that a declined applicant could decide on an informed basis whether to proceed instead on notice. National's bill doesn't include any such provision. Why weaken potential protection for a victim in this way unless the government is simply paying lip service to the interests of actual or potential victims of crime? Fourthly, sir, Labor's bill made provision for applicants to be able to attend information sessions, which would provide advice on making effective use of protection orders and providing advice on any social assistance that might be available. Again, this provision would have been of great assistance to those potentially at risk. Why has it been omitted? Because National clearly doesn't really care about those actually or potentially at risk. Fifthly and finally, sir, Labor's bill also contained much better provisions concerning applications for the discharge of protection orders, and it allowed the court to order reports if necessary. It is simply inexplicable that any government claiming to care about the vulnerable would not have reenacted these provisions. Mr. Speaker, Judith Collins issued a media release on 1 October 2009, and in that media release she claimed that National's 2 new bills, the replacements to the Labor bill that I mentioned earlier, will, quote, tackle the evil of family violence. But in that press release she doesn't make any explanation of how that will occur or why these 5 omissions have been made in the legislation. And we never heard from the Minister in his introductory speech tonight, unfortunately, why these omissions have occurred, nor have we yet heard from a Government Speaker on these matters. So while Labor will be supporting this legislation to a select committee and hopes that it will be able to support the legislation through its other stages, Labor members will be listening carefully as to why these important matters are missing from this bill.